Welcome to Grow Money Business, the podcast dedicated to helping business owners optimize income, pay less in tax, and invest prudently. Here's your host, Grant Bledsoe.
Hello, everybody. Grant Bledsoe here. Welcome back to Grow Money Business. This week on the show, my guest is Asha Paulose. Asha is an asset protection, elder law, and estate planning attorney operating a virtual law firm out of the Hudson Valley, which is about an hour north of New York City. And she joins us today to talk about basic estate planning that most people across the country really need to have in place, especially if you have minor kids that you want to support if something ever happens to you. We touch on a couple items related to business owners as well, regarding whether you should put an LLC or an S corporation inside a trust. This was a really interesting conversation. Asha shares with us some of the common estate planning mistakes people make that you should be sure to avoid, including why you should not add your kids' names to your bank account, why you probably don't want your sibling to inherit your assets that are meant for the support of a minor child, and how to handle spendthrift beneficiaries, disabled beneficiaries, and just a few general thoughts if you have minor kids and want to make sure they're going to be okay financially if anything happens to you. This is a really good discussion. She's sharp. She's been in the industry for quite a while, and I really enjoyed it. And I hope you do too. Hey everyone, I need to interject quickly to remind you all that nothing found in today's episode or any other episode of Grow Money Business should be considered financial, investing, legal, tax, fitness, or even relationship advice. It's content that you're free to use and to deploy on your own terms. And before taking any actions on content found on the show, please do consult with your tax professional, your attorney, or your financial planner. If you don't have a financial planner, head on over to threeoakswealth.com to learn more about what we do in terms of financial planning and investments and how we help clients on an ongoing basis. Hello, Asha. Welcome to the show. Thanks for being on with me today.
Thank you.
You've had quite an interesting career. You launched into the legal world at a young age, and you now focus on basic estate planning and elder law. And that's specifically something that we haven't covered a lot on the podcast, which is why I really wanted to have you on. Why don't you tell us a little bit about yourself and your career and your firm and what you do on a day-to-day basis now?
Oh, sure. Yeah. When I graduated from law school, I really didn't know what I want to do, and I kind of jumped from different fields, but it all kind of led me to this topic, this practice area, which is elder law. It's a mix of legal work and empathy. So I think I have both of those to show the client. So it's nice. We run a elder law firm and estate planning firm. So all that means is estate planning for anybody that walks in the door, wills, powers of attorney, things like that. And then as they get older, I have individuals who want to kind of step it up. Maybe they retired and they want to make sure all their assets are protected, and we'll do some planning for that. Or in a crisis, if someone is sick or if there's a diagnosis of some kind, we'll do crisis planning, and that usually involves long-term care or Medicaid. Then if somebody passes away, their loved ones will kind of speak to me and see if we can close their estate. So I run that full timeline, and anybody who walks through that door.
So tell us a little bit more about asset protection. Why do people care about that? Why is asset protection important?
Yeah, I think that, we have a lot of misconceptions about what happens to our stuff when we pass away. And, no matter where you come from, or I think, we see on TV or whatever, we just think, oh, my kids will get our stuff or my spouse will get our things. If I'm sick, my spouse has access to my things, my kids have access to my things. And I think that's completely a misconception that people have. When you pass away, you have to go through something called a probate process or administrative process. And there are a lot of people that kind of get first bite of that apple before your heirs can accept their inheritance. And we try to prevent that whole process from happening. For example, a basic example is if you have a checking account and you have, let's say, a couple of $1,000 in there, 5,000. If you don't put a beneficiary, then you have to go through, your loved ones will have to go through court. You might have to hire an attorney. They might have to wait a couple of months to obtain that 5,000. And if you owe any money, medical bills or anything, those bills might have to be paid first before your inheritance is received. Instead of doing that whole process, just put a beneficiary on the checking account and that check will be cut directly to the person. And a lot of people have the misconception that won't happen, but it will kind of remove all of that process and go directly to that person. It's a nice feature to have. And so we go through all of their assets and try to protect it from that. Yeah.
Got it. So when you say asset protection, you mean making sure that your client's stuff gets into the hands of the people they want to have it without any other hands getting into the pot. Is that a fair
Yes.
representation? Okay.
That's a fair representation. And then even when you are sick or you're in the hospital for some reason, you're out 2 months, you got COVID, something, it's nice to know, hey, I'm not going to come home to a foreclosure notice or anything. I'll have people who will help me deal with the house or deal with my finances without coming into a second problem when you get home. First it was medical, now it's financial. It's nice to have that that security.
Yeah. Now you're licensed and operate out of New York State, and I'm in California. We've talked a fair amount on the show about revocable living trusts, and in California specifically, why they're really important if you own real assets, and that's because you want to avoid probate, particularly in California, which is a state that's not adopted the uniform probate code. And if you have an attorney, it's my understanding that I think you have to have an attorney represent your estate when you go through probate in California, and they're entitled to a small portion of it for their fee. And it's generally good practice to recommend, if you're a lawyer in California, to recommend that your clients who own homes create a revocable living trust to just bypass that whole issue. I'm curious what's different about New York State, and what are some of the nuances that you have to deal with on a day-to-day basis when helping your clients draw up their asset protection strategies.
Yeah, no, lawyers are lawyers no matter what state you live in. So I'm sure there's ways that we're going to, get a piece of that apple. But I think in New York, it is definitely like California. It's a way to divert the assets and avoid probate, private. No, nowadays, even after COVID, your wills are just public record for everyone to read. And there are some, there's a lot of people that will just sift through all these records and look at your wills. And to have a private trust is a tremendous thing. A lot of people also use it for, if there's a minor beneficiary, if there is a spendthrift beneficiary, if there is a disabled beneficiary, those are all things that can be protected in the trust. So I do like that aspect of it, but it's the same concept in California. New York is not just using it for, if you have a lot of assets or if you own a company, those days are gone. The regular middle-class families are using these trusts to protect their homes.
Yeah, that's been my experience too, is a lot of people hear the word trust and they think that it's some elite tool for only the ultra wealthy, and that I'm just an everyday dude. I don't need a trust fund for my kids or anything like that. And that's not at all what I think professionals are implying. They're just they're suggesting this as a mechanism to keep the government out of your estate as much as possible and just get your stuff in the hands of your beneficiaries as efficiently as possible.
Yeah, it's kind of it's a tall mountain to try to convince people to see how important it is. I really have to really climb it. So I'll tell people it's not, they think it's a trust account. The word trust is used so differently in so many different scenarios. So first they think it's an account, it's in a bank account that you have to put money in. I have to really kind of explain the idea of the trust, and then to say, hey, that house that you've worked so hard to own, we're gonna change the deed and we're gonna put it into the trust. So that's difficult for them as well. So those are hurdles that are, I would say 10 years ago would be difficult for New Yorkers, and now it's become like their regular vocabulary and language. So I'm happy about that, but there's still a lot of misconceptions out there, I'm sure, about estate.
What other vehicles are out there when you're coming up with an asset protection plan for someone? You mentioned if you have a minor beneficiary, a trust is a good idea, and I suspect what you mean by that is you can include distribution provisions within your trust, however the hell you want to set them up. And what a lot of people will do, and a lot of attorneys that I've worked with in the past will do is, if you die while your kids are minors, they're not able to access 100% of their inheritance when they turn 18. They might get half of it at age 30 when they're a little bit more mature, and then the other half at age 35 or something to that effect. And the other two circumstances you mentioned were spendthrift, if you have a spendthrift beneficiary, or if maybe a disabled beneficiary, that these can be useful tools as well. Walk us through the dynamics of those situations. Why might you want to
Yeah,
use a trust in those situations?
yeah. In a disabled beneficiary, you can't. If you're disabled or receiving government benefits, if you receive like a huge chunk of money from an inheritance, then you might lose your benefits. So you don't want that. So what people do is they disclaim that inheritance. So now this person who should have received it has to say, no, I'm sorry, I need my benefits. I can't accept this inheritance. But the other thing that people do is give it to somebody else. So let's give it to your sibling or an aunt so that they can take care of you. And I think that dynamic might be difficult as time goes on. So here is a great tool to have. You place the funds into a trust. The trust specifically says, hey, this can only be used for my disabled child. They're receiving benefits, they can't get it directly outright, but any money that is withdrawn from this trust must be used for their benefit. So it kind of gives the rule to the trustee to follow it to the letter. And same thing with the spendthrift. A lot of parents are very nervous, especially if the child has been living with them, to be like, oh, here's a large chunk of money. It's very jarring for some people to utilize that if they've been living at home with their parents and maybe mom and dad have been taking care of them financially. So it's nice to have this feature that they can say, okay, every couple of months, a trustee will come and give you a portion of it. It's not saying, it doesn't give the trustee, like, the trustee's not God. They can't prevent you from having what is your inheritance. So there's language in the trust that says, hey, if they need the money for um, for a living, for clothes, for medical, and their benefits are not covering it, or the trustee is preventing it, we got to figure that there's allocations to support that. So especially in a minor situation, that's a lot different, Grant. And I don't know if California is like this, but New York there is a huge government oversight when you pass away and you have minor children and you have finances that are left to them. So if you don't put it in a trust and you put it through probate, the government really has their hand on it. So you cannot withdraw any funds unless the check is signed by the surrogate court as well. You can't deposit anything unless the surrogate court has a hand on it. If you need any withdrawal of funds, you have to make a petition to the court. It is an overwhelming thing for guardians who just are taking care of this minor child and now have to deal with the finances. So to have that be separate in a trust without any government oversight is a blessing. So
Yeah.
I really like that tool as well.
Yeah. We've had a couple situations recently in our practice where we've been talking about estate planning and its importance with the client. They agree that it's time to formalize their intentions and create a basic estate plan. And then they say, well, I'd really like to name, this is a single parent example, that they have a minor child under the age of 10, single parent. And they said, well, I'd really like to name my sibling as the sole beneficiary of my assets, all my retirement accounts and so forth, because I know that my verbal instructions to them while I'm living is, hey, if something happens to me, I'm giving you all my assets and you're going to use that for the benefit of my kid. I have tried to push people away from doing that. What is your perspective on this?
I
And
know,
what are
but
some
it's
real
so
life
easy.
examples and reasons we do not want to do that? As much as we love our siblings and trust their decision making.
I think I've seen it a lot where it's just an easy thing to do, and even bank tellers will say that too, like, I mean, they're not your attorneys. They're answering the question you asked. What's the easiest way to help my son who's disabled get their funds? Oh, just give it to your sister. It is so dangerous for a lot of reasons, but the real life examples are, um, that person that you assigned, like your aunt, like your sister, they get into some financial um, problems, like their roof collapses. They need 5 grand. I'm just going to take it out of the account, but I'm going to put it back. There's a lot of that. Or this is actually for him as well because it's for the whole house and he lives in it. So, basically it's his. The other thing is that aunt or that sister could could pass away. And then we don't know what happens to those funds. It is not in any legal authority or obligation for them to give it to the disabled child. It's so sad to say, but that's usually how it works. If somebody predeceases, there's no obligation for their children to have that moral obligation to give it to their children. So
And your child does not have to be disabled for all these rules to apply.
yeah.
By the way, your children, whether they are or are not disabled, if you give your assets, your retirement accounts, life insurance, death benefit to a sibling, and then the sibling passes away, the state can come in and your kid has no entitlement to any of it. And that's probably a better argument than the one that, well, it would be easy for my sibling to access the assets for their own use when really they're kind of earmarked for my kid. Yes, that's a good argument, I think, and it's easy for siblings to rationalize those kinds of withdrawals when they're, when the roof caves in and, I'll just borrow a couple $100 and then a couple months go down the road, down the line and, hey, well, they haven't really provided any financial benefit to the household, so I'm just not going to pay that $100 back. There are a million reasons that somebody in that position might rationalize and justify a withdrawal for their own benefit.
Oh yeah, and justified maybe,
Yeah.
but it's not what the intent of the decedent was. So
Yeah.
it's kind of frustrating on that end, and it's kind of where family tensions come into play as well. I also feel on the flip side, it's also the reason why people, when there's a older parent, the older parent will say, I'll just put my son in the bank account as a joint bank account owner. So then they can, if they need to access funds, if they need to do that, but you are giving your kid, your adult child, all of the funds in that account. And if they get into a car accident, that account is also part of their liability. If they need funds, they can take it out at any time. There's no obligation for them to, worry about your interest at all. So I think the commingling of funds or giving it to somebody by word of mouth, hey, help me out, is very dangerous to that regard.
Yeah. That's a really good point. There are other ways to title accounts, but I think by and large, when people say, "Oh, I'll just add my kid to my account," their name goes on. You walk down to the bank, add their name. They have joint tenancy with rights of survivorship. So if you pass away, their name is the only one left on the account. But since you just added their name, now they can withdraw every single penny if they want to. And I think technically that's a taxable gift as well, right? Whatever is in the account, if you add their name, you're supposed to fill out a gift tax form if it's over the annual exclusion amount of $17,000.
I know,
Is that right?
and clients, it is a gift, and clients will come to me and say, "Oh, but that's my account," and I'm like, I know that's what you think, but it is completely they're under their control as well. And they also say, "Well, then they're only entitled to half." I'm like, "No, they're entitled to the full amount," and then they'll say, well, the will trump, so when I pass away, the will control what happens. And again, I have to say, no, when you pass away, that entire amount goes to your son. And if your daughter is hung dry and can't get those funds, they have no recourse. It's all to the son. So
Yeah.
with all of these situations, they still get the advice of a bank teller, or maybe they've read it on Google or something, and they'll just add their kids as a joint owner, which I understand there's a lot of information out there, but the big thing, especially in elder law, that they do is it's a transfer of funds, and Medicaid has something called a look back period, and they will see, hey, you gave a large gift to your children, so we are going to penalize you for that. So when that happens, they don't even realize it. They're like, oh, I just put them as joint owner. But I said, well, as making them joint owner, you're making a gift, like you had stated. And in the eyes of Medicaid, that is a penalty for them. So.
Right. Right. Yeah, there are all sorts of ways this can go wrong. And what we were talking about earlier, how a lot of people hear the word trust and they say, well, this is only for the ultra wealthy. I don't need to mess with any of that stuff. In reality, this is a pretty basic planning technique. It's a pretty basic maneuver. It costs you a couple $1,000 maybe to get one of these drawn up from an attorney like Asha, but it's not the most complex maneuver. That being said, I have also run into a lot of people who think that they will do this successfully by creating a trust off LegalZoom or something like that. What can go wrong if you download a boilerplate document from a place like LegalZoom?
So I think the biggest thing, and I don't think it's just LegalZoom, it could be an attorney that you just met and just cranked out documents for you. You have to have an attorney that you have a relationship with, maybe meet them a couple of times. But the biggest thing is that it's unfunded. So people will pay thousands of dollars for this trust. It's in a beautiful binder that LegalZoom will provide you, or whatever the case is. But at the end of the day, it is a useless document when they pass away because it has been unfunded. Perhaps you didn't do a pour over will, which basically means that in the eyes of the court, anything that you had, any assets, will go directly into the trust. Or if there's any home that doesn't have a benefit, any home or assets that don't have beneficiaries listed, it doesn't go directly into the trust. So what was the point of it? I don't know. So that's my biggest pet peeve about it. Well, when a client will come in and say, "Don't worry, Asha, I got a trust," and then I look and see, well, your house isn't in this, your cars aren't in this. I don't know what this is for, So that's what I really don't like about it. The other things is when it comes to trustees, there's a lot of people that do two trustees, and maybe one of them is their daughter who lives in California and they live in New York. And there's a lot of times where trustees have to kind of handle things like bank accounts or do things, and they are unable to do anything for their parents because both of them have to go to the bank together, do everything together, sign things together. And it's little nuances like that I check with the client, see what they want to do before I add it into the trust. But yeah, a lot of things can go wrong if you go through LegalZoom. I am not a fan.
Yeah, it's a consultative thing. I mean, you might think that your own situation is really basic and I just have a house. The house is the only thing that's going to go in the trust. I know that I need to formally title the house into the name of the trust, and I'm comfortable walking down to the county clerk's office and paying the fee and doing that. Uh, Everybody's situation has a little bit more complexity than I think we often realize. Funding it is one big part of that, and that's something that I wanted to ask you about as well. When you create a trust, and specifically the type that we're talking about is a revocable living trust. And that's why we say that this isn't a terribly complex maneuver. Revocable means that you can put your assets into the trust, you can take assets back out of the trust. Once the assets are in the trust, if they produce taxable income, you, as the grantor, pay tax ramifications on that, right? So this isn't like a permanent thing. The creation of the trust itself is just the creation of this legal entity that you can then put stuff into that bypasses probate, which is the whole point of it. But
The
you
whole
don't want
point.
to put everything in there. Your house should go in there. Taxable investments and brokerage accounts, cash bank accounts could go in there. But you don't want to put anything that has a tax deferral or retirement benefit in there. Is that right?
Yeah, and I think a lot of institutions will deny that if they try to transfer it in there. But what I do is, when we create this trust, I'll fund it with at least one thing. I'll say, okay, what do you want to put in there? A house? Let's do this. And then it'll be like a 6-month plan where I'll give them a chart. They'll have to write down all of their assets. And then they have to give me an answer. Do you want this to be an owner of the trust? Do you want the trust to be an owner? Do you want the trust to be a primary beneficiary? Or do you want the trust to be a successor beneficiary? So kind of lay it out for them. They have 6 months to decide, let me know what they did, and then submit it back to me. Because I think it's not a quick fix. It's not something that you could do over the weekend. You have to first decide, well, what do I want? Do I want to own it? Do I want to have access? Or what's the decision here? And then, if you're married, you got to both decide what to do. And then you want to decide, should I just give it outright to my children? Or should I give it to the trust as secondary? So it's nice to have those options because you created the trust, but it takes a while for them to decide what to do.
Right.
Yeah.
Right. Now, one thing that I've often wondered about is whether people should be putting their businesses inside their revocable living trusts or not. We have a lot of clients who have mostly their S corporations, but most of our client base consists of business owners. They have fewer than maybe 25 or 30 employees, but they have a fair amount of complexity. They want their family to benefit from their hard work in developing their businesses. And so they're assets of that business. Many of them have their own succession plans. When should you put a business inside the trust and when should you not?
Yeah. I don't know if I could speak to that, Grant, but I can say that there's a lot of clients that come to me without any kind of plan. And it's very terrifying when I talk to them. Like they don't have a power of attorney, they don't have a trust. They're just commingling everything. It's a lot to look at. So what I do is I say, let's just take some baby steps, do a power of attorney, so at least if, God forbid, something happens to you, someone can kind of step in and figure out what the business is and divvy it out. But past that, I've heard that most people in New York, what they like to do is create that LLC, create that whatever corporation, and then place it into a trust. But I'm a little nervous about that because it's your personal assets commingling with business. How do you feel about that? Especially as a married couple, like it might be a little risky to do all that and then maybe have to undo it later. I'm not sure if I agree with mingling the two.
Yeah, my thoughts have always been that, designed perfectly, any liability that the business is responsible for would not pierce the corporate veil, as they say, right? So if your
Sure.
business is an LLC, if your business is an S corp, I always use the example of selling ice cream cones. Let's say that we sold. You and I started this business. We formed it as an S corporation, and we sell ice cream cones. So we go buy a bunch of milk and cream. We make ice cream and all that. And then we sell them. Somebody gets salmonella from them, and they get sick, and they sue our business. Well, if that's part of the reason that we like to structure a corporation or an LLC in the first place, is plaintiffs can come after the assets of the business if the business is liable for those damages, but they cannot come after our house. And so what I hear you saying is, if we place that LLC or that S corp in the name of our personal revocable living trust, there could be some commingling of assets, and maybe the ability to pierce the corporate veil is stronger from the perspective of a plaintiff. And that is a little bit treacherous and a little bit scary, but to be clear, I don't know the legalities of it. So maybe it does make sense.
No, I think attorneys can argue one way or another, but there's a strong argument to say that there's a commingling involved, and so we shouldn't treat them separately. But, what I have found is that business owners are hesitant to lose control, and placing it in a trust is way above what they want to do. They want to have complete control over the business, and they don't want a lot of people looking into their finances and what they're doing. So to make smaller changes and just say, okay, let's just take your building, let's see if we could put that into a separate revocable trust so that if something happens to you, we won't have to worry about that. Or let's do a power of attorney. So I try to just have at least smaller changes so they're not completely hung out to dry. But to offer that would be a longer conversation that I'm not sure if they would hear out.
In my experience, 99.9% of the time, so aside from the liability component of it, if you're putting the business inside the trust and then something happens to you, then there's a successor trustee, there's a beneficiary involved, right? And so if the trust is for you and your spouse and you pass away, now your spouse is inheriting the business, but they're also in a position where they need to continue running it. If you and your spouse both go, then your beneficiaries are inheriting the business, and they're not inheriting cash. They're inheriting the business. And if your intention is to preserve the value for the benefit of your family, which is true of almost everybody I've ever had this conversation with, then you're probably far better off spending the time and effort on a succession plan that will reward your family without their having to step in and operate the day-to-day. And if you have partners, then that could be some kind of buy-sell agreement. Maybe it could be an agreement with a third party or a bigger entity to where if something happens to you, they swoop in and make sure that the lights are kept on, all the employees have jobs, and that your family's paid out and all that. There are a million ways to do it, but generally setting things up to where one of the beneficiaries of your other stuff is also going to inherit this business that all of a sudden they have to step in and run when they have no involvement in that now is just a huge leap. It's never going to work.
It won't work. And I started this virtual firm last year in March, and when I was creating all these business plans and listening to all these webinars, all of them said, oh, you have to have a succession plan and well. And I was like, I don't even have a book of business. Like, what do you mean it's a succession plan? But all of them said, like, that's what you need to do in order to move forward. It's peace of mind to know, like, hey, if something does happen, someone's going to step in. And it was very beneficial at that time, even though it felt extremely silly.
Yeah, it often does. And that's the thing that for entrepreneurs, it is so easy to deprioritize, right? If you're in a position where you've started and built and grown a successful company, you've done that because you've probably been a little foolish and haphazard along the way. I mean, the people that get to that position are usually people who think that they're somewhat bulletproof. They're a little bit, alpha personality. And planning for your own demise is something that always gets pushed to the bottom of the list.
Oh, definitely.
And it's just really common. But it doesn't have to be anything elaborate. You don't have to go out and buy an insurance policy to fund it. You can just say, you can have some agreement to where maybe it's a competitor of yours or somebody else in town that does something similar. Have some kind of agreement to where if something happens to you, they're just going to step in and make sure that your customers are taken care of and the lights are on, the employees have jobs. That could be it. It doesn't have to be elaborate.
Yeah, I agree. And I think, I've seen a lot of law firms in New York or just an individual's law practice like me, where they didn't have a succession plan. And it's just, the spouse trying to call clients and be like, sorry, this is what happened. And their 30 years of work, that book of business that could have had, that has such high value to another attorney has just been, thrown out the window. That's what I feel. I'm like, oh man,
Right.
you did all this work. You've made relationships and it was valuable to them at the time, but just thrown out the side. It's very hard to watch sometimes.
Yeah.
The person and yeah.
It's sad. It's sad. I've seen it myself. So how is business going for you at this point? You launched this firm virtually a year ago after, and where were you practicing before then?
I was practicing in the Hudson Valley area at the elder law attorney's office. It was so nice. I learned everything I needed to know. And then that office actually closed down. So then I had to kind of force myself to do this. And it turned out to be the best thing. I didn't, if you asked me 5 years ago, I'd be like, no way am I going to work for myself. But I think COVID really changed that. I think I took a lot of classes and, they really kind of reframed my mind about certain things. I thought, oh, I got to get an office. I got to get fancy library books behind me and get a leather chair. I thought I had to do these things. And a virtual firm has been such a blessing because I don't have to do those things. I can, have a lower overhead. I can start right away and I can just focus on the clients. So it's been very nice.
So how do you go out and find new clients then? If you start totally virtually, how does that work?
Yeah, there's been a lot of social media. There's been a lot, just LinkedIn, Instagram, Facebook. That's really been my friends. But I do have the privilege of being first generation here, and the community that I grew up with. They're all elders now. They're all first generation. So we're all learning together in that sense. So it's been nice to kind of educate the community that I grew up in and try to help people in that regard. But then randomly, I'll have people, I speak at the library or I'll speak at community events, and then I'll get business that way. So there is no right formula for marketing. That's what I feel. It's like I just do things like spaghetti on the wall, and it's somehow something sticks and it works out, or I'll do something and 6 months later it will pay off. So it's wild how that works. I don't know if that's the same for you, but it's been wild how I get referrals.
Yeah, it's somewhat similar for us too. What I found over the years, and we're coming up, as a matter of fact, on our 10th anniversary here next year. You're just, all your marketing efforts are just planting seeds. You're just planting seeds, and you're kind of watering those seeds over time. And if you can add value to someone in a way that helps them without them becoming a client, that's a win. But if you can add value to someone and it's a good fit, and then they do become a client, that's ultimately what you're after when you're growing a firm. And you never know when or where or how those seeds are going to sprout, right? Nobody, I suspect in your field, there are situations where people are in dire circumstances where they need your services immediately. In my field, nobody really wakes up in the middle of the night with a cold sweat because, I need a comprehensive financial plan, right? It doesn't work like that. There is some other triggering event that is the reason that they're reaching out to you that may not have been the case when you first made contact. And so the
Yeah.
idea is you go out and plant a lot of seeds and doing different things like this podcast and social media. And we have an email list and we do speaking engagements and that kind of thing too. And yeah, you just never know where they're going to sprout. But the key is
Yeah.
just being educational, and what's worked for us is just helping people as much as possible.
Yeah, that I remember reading like you gotta kind of be in their face 7 times before they actually call to get the services. So whether that's Instagram, whether I see someone at a birthday party or at the soccer field, it's just 7 times before they're like, all right, let's make the call. But we talked about college before, and I was a marketing major, and all of those things are just out the door whenever I learned, because it's like a brand new day now, and there is a lot of things that worked then that won't work now. I mean, even just the virtual firm, no way did I know that, seniors would learn how to Zoom, 5 years ago.
Yeah.
I thought that would never happen, and now it's it's everybody knows how to do that, and so it's more feasible to do a virtual firm like this. But also, I didn't have to learn about branding and being more accessible to people, and making videos like we had talked about. So it's a learning process, but I'm loving every moment of it. Just since starting last year.
Right on.
Yeah.
Well, I'm glad to hear it's going well for you. What is your website? Where can we direct people who need some elder law or estate planning help in New York State?
Sure. You just go to ashapaulose.com, and I'm very transparent in there. I believe in it. So pricing is there, the process is there. Clients love, we do a portal, so all of my messaging, any communication I have, any documents are all listed in there. So it's nice for people who are kind of on the go, don't have time to go to an office. They can meet with me virtually over Zoom, or I go to people's homes, and it's a very family-oriented practice that I have.
Right on. Well, thanks for spending a little bit of time with us here today, Asha. These concepts, estate planning and asset protection and so forth, what goes in the trust, what doesn't, why do we have this? We've had this conversation a time or two with other estate planning attorneys on the show over the years, but I think it's always a helpful reminder to go over the nuts and bolts, because this stuff has really substantial impact on your family's financial situation over time. And like we're talking about, man, it's just easy to deprioritize it because we all think we're infallible to some degree.
Yeah, I
Everything's
think
going to happen to you.
not only infallible, it's like you just have a misconception about what will happen to your stuff, and you just got to get the right information about everything you own, because we all worked hard for it. You don't want it to go to waste, so why not talk to an attorney for 10 minutes or 1 hour and figure out what's going to happen. So,
yeah, absolutely.
yeah.
Well, thanks again. Best of luck in the firm, ashapaulose.com, and we will talk to you again sometime soon.
Thanks so much, Grant. I appreciate it.
Thanks for tuning in to Grow Money Business, the podcast dedicated to helping business owners optimize income, pay less in tax, and invest prudently. Be sure to subscribe to the podcast on iTunes, Google, Spotify, or wherever you digest podcasts to ensure you don't miss out on future episodes and announcements, and feel free to submit questions to growmoneybusiness.com.